Today we will talk about what conflict of interest is, why it is important, how it plays a role with confidentiality and privacy, the importance of professional relationships with board members and stakeholders, and finally, outlining expectations in managing social media. A conflict of interest may arise when an individual's personal interest could compromise their judgment or action in a professional or personal setting. Appointed board members must always be aware of situations in which conflict for them may arise when making board determinations. Let's talk about the 4 types of conflict of interest. Financial conflicts. This may occur when an individual's financial interests may influence their decisions or actions in a way that is not in the best interest of the board that they represent. Personal social conflicts. These relationships, such as family or friends, could compromise an individual's ability to make an impartial decision. Confidential conflicts. Knowing or having access to private information that could be used for personal gain. Competitive conflicts. An individual may take part in an activity that personally benefits themselves at the expense of the board. Now let's look at why understanding conflict of interest is so important. It is common that conflict of interest can come up in the workplace. As a board member, different situations could arise. An example of a conflict of interest may be if a non-routine application comes before the board for review and the applicant happens to be your nephew. This is a clear example of a conflict of interest, as your nephew, being a family member, could potentially benefit from your input on the decision made on his application. It's important to understand your role when it comes to confidentiality and privacy. Protecting confidentiality in a conflict of interest situation, a board member may provide very limited information regarding the conflict. Going back to our earlier example, if your nephew is going before the board, you may simply say as a board member that the applicant is a family member and that you will need to recuse yourself from making a decision. By utilizing aspects of confidentiality for conflict of interest, a board member is protecting the privacy rights of themselves and others involved in a potential conflict of interest. Let's jump in to talking about board members and stakeholders and what the expectations of those professional interactions should look like. Some important things to remember are: board members are prohibited from conducting private meetings outside of full board meetings. This means they cannot participate as other parties in the dispute. Board members cannot discuss the details of a disciplinary action with the subject of the complaint or with any other members of the public other than board members, except at a board meeting in the presence of legal counsel. Do not meet or confer with other board members about board business, except at noticed board or committee meetings. Doing so violates the open meetings law. This includes meeting in person or conferring on the phone, by email, or other electronic means. Now that we have discussed some of the expectations of a board member, let's look at the relationship between stakeholders and conflict of interest. Board members must remember that outside stakeholders are not privileged to the board's business. Working effectively with stakeholders takes well-organized conversations, and board members should always have permission to formally represent the board in a stakeholder conversation. And finally, board members must not lobby with stakeholders. Let's talk about the why and look at antitrust laws and non-competitive concepts. Antitrust laws are designed to promote competition and prevent monopolies and other anti-competitive practices. In simple terms, they aim to ensure a level playing field for businesses and to protect consumers from unfair practices like price fixing or market dominance by a single company. The purpose of an antitrust law: promote competition and efficiency in the marketplace. Protect consumers from the growing monopoly power of big business. Maintain a high level of competition among producers so that consumers are able to get products at affordable and reasonable prices. A government-appointed board member could violate antitrust law if they act to restrain competition in their jurisdiction, even if they act in good faith. For example, a state regulatory board controlled by dentists could violate antitrust laws if they prevent non-dentists from offering teeth whitening services. This is because their actions would be seen as restricting market entry and restraining rivalry. Our final piece of talking about conflict of interest today involves social media. Social media plays a significant role as a board member, and it is important to know the best ways to navigate avoiding conflict of interest within the social media world. There are a few do's and don'ts when it comes to your role as a board member when it comes to social media. A few things to remember. Do keep your personal and professional accounts separate. Do be professional and maintain a respectful demeanor when engaging in any social media opportunity. Don't discuss or share confidential information or board business on a social media platform. And don't share personal opinions that could be misconstrued as representing the board. Here's some additional items to consider with the responsibilities of a board member. Complete your disclosure form. Remember to consider your potential conflicts. Ensure transparency and build trust. Be proactive. Consider any potential biases. And if you have any questions, please talk to the staff. Thank you for taking the time to watch this presentation today. I hope you leave today understanding what conflict of interest is and why it is important, how to recognize potential conflicts of interest, and how to address and handle any situation that may present a conflict of interest.